one of our guests, Sarah Bevan of Loris Technologies Inc., who will be telling us something that I think is a spin-off from one of the presentations that I'm going to make about his business, Loris Technologies. Please make him welcome.
Thanks, Georgia. Thanks for the introduction. As you know, I'm the CEO of Loris Technologies. We're based out of Toronto. We're a software developer. We do one thing and one thing only, the development of enterprise document management technology. And our current client base would employ millions of people, generate hundreds of billions of dollars in annual revenue, and control trillions of dollars in assets worldwide. Additionally, we've been doing this for 30 years. We have a client base across North America and in Europe. We're also partnered with Microsoft out of Redmond, Washington. Our deployments are in a broad range of industries, from banking to healthcare, to securities, to retail, to insurance, to a broad range of departmental applications, whether it's customer service, finance, HR, and so on. I think what George is going to be talking about today is a lot of the things that drive clients to come to us revolve around concerns about record security, privacy, record retention, but also about the kind of workflow issues you have in finding documents and managing them, keeping them secure, and so on. Our technology is able to capture, archive at bank level encryption, and then enable you to automate workflows, and really could apply anywhere. Our stories are extensive on our site about rapidly changing the way organizations do things, paying for the change out of third-party costs. And so we are partnering with tTech in Jamaica and the Caribbean, and with Microsoft to offer our technology in the cloud. One of the things, I was the chief operating officer of a multinational in Canada. I never saw a software program go on time, or on budget, or do half of what we expected it to do. But with tTech, we're working together. We're offering a cloud-based solution. It's going to offer the ability for you to start small and go across the enterprise. And we're going to guarantee everything. So where before you had software that you would worry about and involve large capital costs, we're going to make something that makes sense from a privacy standpoint, retention, disaster recovery, workflow, and your risk will be nominal. In fact, we'll lose it if we don't make you happy. So with that said, and I said all the infrastructure will be provided by Microsoft in the cloud. So I would like, with that further said, I'm going to be around a little later on today and get into a bit more about what we do, but I'll turn it back to Georgia. Thank you.
Thank you, sir. I'd like to thank tTech for inviting me to make a presentation on what I found to be a very exciting area, but a bit challenging for some based on the responses that I've been seeing in the media regarding the Data Protection Act, or the Data Protection Bill. We are just basically coming up to where world standards are in relation to data protection. Data protection is basically about privacy, and privacy of personal information, and the responsibilities of those who have access to personal data, how they treat with it. So recently, when I've been doing presentations around, for example, like the Cybercrimes Act, what I have been speaking to organizations about is about developing a culture of ICT governance. So we had corporate governance as a big burst after the financial crisis. We talk about ICT governance and we hear that IT is not given priority in organizations. But now we are seeing that we now have security issues as they relate to personal data and our networks, having regard to the Cybercrimes Act, having regard to now the data protection legislation coming on stream. and you are no strangers to this whole risk relating to personal information. After all, Facebook is now before the US Congress testifying because of how they treat with personal data. So I know that I'm speaking to persons who have had more than a passing acquaintance with this whole concept of personal data. Is there a clicker? No? Okay. Because I'm sorry, I hadn't seen that the screen had come up behind me, so all that I was saying, it's not necessarily related to my presentation. I was just filling because I was watching that screen over there. So, it's not all off topic, but so the context that I was saying in which we talk about personal data. So what you'll be seeing on the screen now is various types of concepts. But the context in which we began to speak about data protection, which basically is the use of computer, and the way in which computer makes it easier to abuse, manage, capitalize on, manipulate information. And you see now that when we talk about data protection and personal privacy, you see the various areas on your right of the screen there about which we are talking when we talk about protection, because these things, as you will appreciate, is what is important to advertisers. It is what is personal to us, and it is the kind of thing that I would not say enterprises would want in order to make certain decisions in relation to our habits. And that is the reason in the context in which data protection came about. Data protection and privacy, it's necessary to regulate it, but in the context of privacy by itself was also specifically introduced into our Constitution in the Charter of Rights in 2011 by Section 13.3J. Now we are a little bit behind in terms of where we are in terms of data transfer, talking about data privacy, because most of the discussions now in Europe and in North America center around data in the cloud, which is what that issue with Facebook is about. I'm talking about cross-border transfers, and that is a little bit of where I'm not saying that our personal data is not important in terms of our relationship with data controllers, but one of the, depending on the industry that you're in, one of the areas in which you are going to have some concerns as well is how you store personal data when it is in the cloud and that kind of cross-border transfer. So when I spoke initially about ICT governance, IT security, that is where companies like tTech will come in. So increasingly I've found that when I'm doing these presentations, I'm always having to call on some enterprise who deals with IT security or IT management or records management in order for people to appreciate what the tools are or who to go to when it comes on to assisting them with compliance. So we have to commend tTech for this initiative in terms of placing the Data Protection Act within its proper sphere, that is information technology and systems. So next slide please. As I was explaining, that you can see that data protection came in a context of protecting privacy, and they started out with certain principles in the United Kingdom. So they had commissioned a report known as the Younger Report, and you see that they were saying now that information must be held for specific purposes. So you can't ask for whole people's information for more than you want or take too much information from persons. So I've written held, I've put that in bold, because throughout, even if I don't say it, what you will be realizing that whether you have a manual system, which it would be surprising me if anyone here still has a completely manual system, in terms of holding the data, it is talking about how it must be held for a specific purpose. And it talks about how the information collected and held should be limited to the minimum period required for that particular purpose. And the question, of course, is going to be, what kind of systems do you put in place to ensure that you comply with this now that they're putting into effect a data protection regime? It says, where the system is computerized for statistical purposes. And no, it's not only for statistical purposes, we know it's basically for everything. Everything we do is basically on a computer. And so we have to make adequate provision for the design and programs for separation of identities from the rest of data. And so, procedure where the subject must be told about the information collected or held in relation to himself. And you see, it is again talking about the level of system security that is going to be specified in relation to the system, the monitoring, and system design. So everything that underline or is a backdrop to this whole concept of data protection, as you can see, was spoken about in the context of computers, spoken about in the context of monitoring, spoken about in the context of how you are going to ensure that this data is protected. So that is the backdrop before the 1990. Oh, you're not hearing? Okay. The concept behind which formed the backdrop to the 1998 United Kingdom Data Protection Act. When you look at the data protection bill that is now being discussed, it is almost a photocopy of the Data Protection Act of United Kingdom. So that certainly from a policy perspective, you can be guided by some of the law in that area in terms of the interpretation of the Act. And some of it, well, all of it, would have come then from the general data protection regulations based in the EU. So it is a regime, I call it, for driving compliance with this whole concept of data protection and personal privacy. That is what the Act is intended to achieve. So in order to do that, as lawyers, I was saying to my husband this morning that lawyers talk, even when we think we are speaking English, we speak in a really funny way that people don't understand, and we think that they do and they don't. So I'm going to ask you to help me that if there's anything that I say that you don't understand, I want you to let me know, because we make assumptions, lawyers that make assumptions about what people understand, because that's how we talk every day.
So you're in the IT industry. Yeah, exactly.
Oh, I see. Good. Good. So I'm in good company. But as lawyers, in order for you to understand the data protection regime, how we speak and how they impose these obligations on you, they talk about duty, they talk about breach, and they talk about damage. Duty, breach, damage. And then after damage, they either talk about they talk about sanctions generally, but when they use the word sanctions, they're talking about criminal sanctions, and compensation, we're talking about civil compensation. So in a real sense, that's the structure of the Act. It sets up a duty on some persons, about some persons, and then it sets up the rules as to how you are going to comply with the obligations that you have imposed on some persons. So that's where we're going now. So we are saying that the way that the Act is structured is to drive compliance. So, in terms of enterprises, slide please. In terms of enterprises, who is subject to the data protection legislation in terms of duties? So remember, the name of the Act speaks to what it is intended to do, data protection, and the underlying principle of privacy. So who is subject? Anybody who handles any form of personal data whatsoever. Any handling of personal data. So it's very wide. And it applies basically to the processing of that information. And it includes all activities in relation to that data, such as organizing, retrieving, disclosing, transmitting, aligning, combing. Even if you're blocking the data, you're erasing the data, even the destruction of the data to make it anonymous, bringing it up on a screen is processing the data. So you can see that basically every enterprise who handles personal data can become subject to the Data Protection Act. And the first obligation that the Data Protection Act creates on those who handle personal information is this whole concept of registering with the enforcer, who is known as a commissioner. And there's that enforcement mechanism as well, which is separate and distinct from the courts. Now, remember we spoke about duty, breach, and damage. So the backbone of the data protection legislation I'm going to ask your permission to take off my jacket, please. Okay. It's kind of getting warm. Right. So the backbone of the compliance or the Data Protection Act, it has these 8 standards or principles of data protection, which must be observed by data controllers. 8 standards. And so what it says is that personal data shall be processed fairly and lawfully, and in particular shall not be processed unless one of the conditions that is set out in the Act, which is 2 sections 23 and 24, are met. Now you have heard me speaking about personal data. I'll get to the point where I define the concepts, but you will find that there is a dichotomy and a separation between personal data and sensitive personal data. And that is, again, as I keep saying, that's why I started out the way that I did, that you're going to find that you need Chris more and more, because you're going to have systems in place that help you to comply in terms of how you treat with personal data versus sensitive personal data. And so the conditions of processing broadly are that the individual must have consented. And you see what processing is. I told you what processing is, even handling it, bringing it up on your computer screen, taking the information. In cases of emergency, if there's an emergency, you can go without the consent. When it is in the public interest, when there's a legal requirement or authorization, and when it is required for the execution of a contract. And there are additional considerations, riders as it were. So it's not the consent in relation to sensitive personal data, but in relation to sensitive personal data, it can be processed in order to protect the vital interest of the subject. So there must be some technical method, as you would appreciate, to parse out or carve out how you treat or handle personal data as distinct from sensitive personal data. Now there is standard number 2. Can you go to the next slide, please? And you'll see that it says, personal data shall be obtained only for one or more specified lawful purpose and shall not be further processed in any manner incompatible with that purpose or those purposes. So maybe when I think about it, is those unwanted texts that I get from people that I never ever walk into their store trying to sell me things. So it tells me that something like my phone number, which whenever I call some people, or when you come to know me, you're going to, when your phone rings, you're going to say, hello, Georgia, and it's not because my name is on your phone, because I'm cussed out for being one of the few people who still have private on my phone. Nevertheless, I will still find that I'm getting ads, as it were, on my cell phone. So it must be because my personal data was handled in a manner that I had not authorized. And so here it is now that an obligation is being placed on providers to say, when I give you my data, for example, if I gave you my data because I wanted a telephone or because I wanted email service, then you can't sell that data as, well, I won't say Facebook sold the data, but as happened in relation to Cambridge Analytics, taking that data and doing what they did with it in relation to the US elections. Because a lot of people never knew that their data was passed and used for that purpose. Standards 3 and 4. Yes. You see that personal data shall be adequate, I like relevant, and not excessive in relation to the purpose or purposes for which they are processed. I'm so happy for this Data Protection Act. Hope anybody will string me up, but I like it. Because so often you go into organizations or you want to access a service, and the amount of information that is being requested is not necessarily required for the service that you're going to perform. And it says personal data shall be accurate and where necessary kept up to date. Backbone of compliance again, standards of data processing 5 and 6. So what you'll be finding is, as tedious as this is, you're going to have to become lawyers in a sense, or have someone in your organization who knows what these are. And possibly maybe I can put up a chart so that or you have the thing in relation to employee policies in terms of what they can or cannot do just in case they injure themselves. Maybe you can have that as well on the wall when people walk in. It's just 8 of them. You can paste them on a wall, or you can send out an email every day or on the email server or something. Don't take me seriously now, sir, because I see you putting up your hand. Alright, since I'm dealing with the standards, and I said that there are 8, maybe when I reach number 8, that would be a good time. Good. So, personal data processed for any purpose or purposes shall not be kept for longer than is necessary for that purpose or purposes. And it must be disposed in accordance with regulations. And I said regulations to be made, because you know that for Jamaica we're just talking about the act. No, the regulations would not yet be in force or maybe even thought of. Personal data shall be processed in accordance with the rights of data subject, and I will get to the rights of data subject shortly. And so now we get to standards 7 and 8. And so, again, you are seeing it coming through the common thread that you will not be able to do it on your own. They have put in now as a standard that appropriate technical and organizational measures shall be taken against unauthorized or unlawful processing of personal data and against accidental loss or destruction of or damage to personal data. So this sounds like what is happening with all those people like Target and so on who end up losing your personal data for whatever reason, or because the hackers are just pretty smart. But then, because we know that the hackers are pretty smart, then that also affects the technical measures that you put in and affects, in turn, the question of whether you are found liable or not in relation to the accidental loss of data. And then, personal data shall not be transferred to any state or territory outside Jamaica unless that state or territory ensures an adequate level of protection for rights and freedoms of data subjects in relation to the processing of personal data. And as I was explaining to my table earlier, or maybe I might have said it when I came up here, but question of age, I can't remember if I said it before, so I'm going to bore you with it again. The big issue at this stage in relation to a lot of the jurisdictions that are dealing with data transfers, well, dealing with the personal data is about this data transfer. And a big issue is going on in the EU now where they are set to change the law to make it a little bit more stringent in relation to how data is handled. You will hear about cases, Yahoo case about the right to be forgotten is in this kind of context. And the US, which with a more relaxed regime, it is alleged, versus the EU, which is a more stringent regime. We have adopted the 1998 UK Act, which means that we have a more stringent regime, which is all the more reason why we have to pay attention and take care in relation to how we treat with data. Sir, you were going to ask me a question.
Yeah, there are a lot of terms here, adequacy, relevance. What are the definitions of these things? And how do you define them for different organizations, different types of businesses? Because in IT, we have to have some, it can't be nebulous.
But it's not, well, you're saying in IT is in terms of the organization, so adequacy is always going to depend on the circumstance. You're right, when you say it depends on the organization. So one size will not fit all. I can't stand here and say to you X or Y is going to be adequate, but I can stand here and say that because it imposes on you an obligation to protect data, you need to show that you took some measures as opposed to no measure at all. Adequacy is going to depend, in my mind, also on practice, on custom, on what is the available technology, and they may even get to the point where it's also depending on the size of the organization. So if I were asked to argue a case, or I know that if judges are looking at the case, those are the things that they tend to look at in terms of what is adequate, because they're saying what is adequate having regard to all the circumstances. So how could you not have, for example, avail yourself of, say, education as you are now doing to find out what the act is about, and then your defense is going to be, well, I don't know. So that is one thing that would be X against you. what is the available technology to protect data? So some people will answer and they will say, oh, I don't have any money, it's going to be a lot of financial cost. And then the lawyer on the holding side will say, no, if I have this open source or free software out there that could be manipulated in such a way as to provide even a minimum level of protection. So that is how adequacy is going to be defined. What is out there? What do you have in place?
Yeah, but I am going down to a lower level than that. What pieces of data do I collect from that person? How do I determine?
Hold on, your first question was answered in the standard. Maybe you should wait until the presentation is finished, but you ask what pieces of data and.
Adequacy speaks to that. Relevance speaks to that. I mean.
So let us finish the presentation then, because what you are asking, adequate data is only going to be, as we say, personal data, and I'm now going into defining for you what is personal data. But there was no point in my mind in starting at the definition without confusing you with the words. Yeah. Because I'll just be standing here telling you definitions. So that's what I'm saying. Now that I realize that you're listening, the next slide is who are the key players? And so, who are the key players? So I start then with the data controller. So who is a data controller? So the Act itself says that the data controller is a person or a public authority who either alone or jointly or in common with other persons determines the purpose for which and the manner in which personal data are to be processed. I'm going to pause there. So if you thought of that definition, a data controller is a person, forgetting the public authority, who either alone or jointly in common with other persons determines the purpose for which and the manner in which personal data are to be processed. And we have already defined processed, which almost sounds like if you look at the personal data, you're processing it, right? So you go to a bank, as an example now, to take out either a loan or a credit card. What is the information about you that the bank requires for the purpose of processing that application? Your name, your address, your employment, and from another third party who would also be a data controller for these purposes because of where Jamaica is now in terms of our commercial development from a credit bureau. Purpose. Do they want your blood type? Purpose. So that's all I'm doing. So when you ask those questions, it says, you notice, in a sense, the act is almost like self-explanatory because it says, is a person who collects data for the purpose for which they are going to be dealing with the subject. So you need to tell me your name, from now on, I'm calling your name a lot. What's your name, sir? Michael. That's going to be easy for me. Good. I saw that, I heard that, Chris.
Yes, okay.
So the data controller, it's a wide definition as well, so it extends to any person who is authorized to process data by reason of law. So I'm thinking, and I'm not causing any controversy, and I'm not going to talk about it because I was asked to talk about it, but maybe like NIDS. So under the law, the NIDS law, you realize that by reason of that, they will be taking certain data, which has caused a lot of controversy out there from us, right? That's NIDS. But what about the Registrar of Births and Deaths? By the reason of the Registrar of Births and Deaths Act or records, they also take certain information from us beside the hospital as soon as the child is born, or if you visit one of their agencies or you go to the Registrar General's Department. So that again is another example of an enactment which allows someone to collect information from you and the purpose of it. So it says, for the purposes of this section, all sole traders, partnerships, and companies are likely to be data controllers. I'm telling you that. So if you're sole trading, that means set up business by yourself or in partnership with others, or you're separate, or you're a juristic person, a legal person like a company, you'll be a data controller. So additionally, unincorporated associations will be data controllers, as well as schools, local authorities, police forces, hospitals, and government departments. And I just gave you an example of 2 government departments that would be data controllers. And so the Act will apply to data controllers located within Jamaica, or data that process, or persons that process data within Jamaica. If the entity is established out of the jurisdiction, it must appoint a data protection representative within the jurisdiction if it uses equipment to process data in Jamaica. So the jurisdiction of the Act is in Jamaica. Any data, personal data that you handle or process or access will be regulated and will make you a data controller. The next person that we are dealing with is a data protection officer. So who is a data protection officer? A data protection officer is a person who must be appointed and paid for by the data controller to report you to the commissioner if you don't comply. I want you to remember. It said the person must be an independent person. It must not have any conflict of interest. And if that person is an independent person that is responsible for monitoring compliance. And it says that when a violation is detected or a contravention is detected, the role of the data protection officer is to advise the controller of the violation. If it is not resolved within a reasonable time, then that person who you are paying is required to report it to the commissioner. But it helps to keep you on your toes, so why not? Okay? Then there's the data subject. That's you and I. So the data subject is a named or otherwise identified individual who is a subject of personal data. Notice it says individual, so that it's a living person. It's not a legal person. So it can't be Bank of Jamaica, for example. It's not a data subject. tTech is not a data subject. But Christopher, as an officer, is a data subject. Alright? So account will be taken of all means used or reasonably likely to be used by the data controller or any other person to identify the individual, such as an identification number, your electoral ID, your PIN, your driver's license, name, any identifying characteristic, whether physical, social, or otherwise, which are reasonably likely to lead to the identification of that individual. And so it follows from the definition, as I said before, that it has to relate to a living person. Then there's the data processor. So there's the data controller, and then you have the data processor. And so the data processor in relation to personal data is a person other than an employee of the data controller who processes data on behalf of a data controller. So this, I think, covers where you have outsourcing. This covers where you will have outsourcing in terms of treating with the data. So that's a data processor. And these are parties to whom data data controllers outsource the processing of data. The data processor must act only on the instructions of the data processor regarding the processing of data. It has no duties at all under the legislation. It's not an employee, but it's an agent. So the data processor is not an employee of the data controller, but the data processor is an agent. And that tells me that because the data processor has no duties under the legislation, the ultimate responsibility for how the data processor treats with personal data is going to be that of the controller, and that is what is going to, where the liability is going to lie. So it means that you have to have a system by which you control your data processor. And examples of data processors would include companies or sole traders engaged in payroll administration, debt collection, web hosting, and private investigation. So that the data controller, as I said, is required to enter into detailed arrangements to ensure that the their obligation is ultimately met. Alright? So that was the data processor. So now, that was the who under the Act. So we say what is the subject matter that the Act is dealing with. And the Act is dealing with data, which if you're all in the IT field, I know you know that the data is information, is that invisible thing that we all talk about. What it is, information is data if it is processed or recorded with the intention of being processed by equipment operating automatically in response to instructions given for that purpose. Is that you people call executable? Yes, so it's instructions, it's just how a computer works. You put in some things, push in the information, and voila, a form comes up with all the information in your print. Data. Or you verify, you don't print, you click send. Or you upload. Alright? And it is recorded as part of, so that's one definition. Or it is data if it is recorded as part of or with intentions that it should form part of a relevant filing system of manual records, or it forms part of an accessible record. Accessible record is a public record, which is health or educational information, which you know that health information in particular is also specifically subject to regulation by itself in the United States, even though they also have data protection. So they have HIPAA, I think, yes. Then there is personal data, which, Michael, you with me still? So we can agree then that personal data is for a living person who can be identified, and from data or other information in possession of the data controller. Then we have sensitive personal data. And sensitive personal data is any of the following information relating to a data subject. I had planned not to write them out, but I think it's important because of where we're getting. I lived in Canada for a little while. One of the things I liked about Canada, nobody can ask my age. Sensitive personal data. So, and based on where we're going now in Jamaica, his sex life, that is sensitive personal data. The conversation that we're having now in Jamaica, there's no point. You can roll your eyes, do whatever you want to do, but you can't ask the person who's sitting in front of you anything about their sex life. I don't think we ever ask though, but maybe we ask, but don't say. But you can't do anything. And again, talking about personal data, why intensive personal data and purpose? So somebody is applying for a job, you're going to ask about their sex life, as you see, when you talk about purpose, relevance, and adequacy. So here are some of the examples that it is sensitive personal data, but what on my credit card application, for example, or in my employment that would require you or make relevant, use the word that you use, make relevant my sex life. It talks about genetic or biometric data, filiation or racial or ethnic origin. Filiation, is basically if you were born within or without wedlock. Political opinions, philosophical beliefs or religious beliefs or other beliefs of a similar nature. And some of these things are not new, because in court, for example, your religious belief is important to you and it's observed. So if the Rasta go in and they want to swear Hajar, Safari, they're allowed. If the Jehovah's Witness goes in and they want to affirm and not swear, they're allowed. So all of these things, some of them, we scoff at them, but they're important. And then this one is his physical or mental health or condition. Every time when I tell you one of these, you go back to the standards which talk about that the data or sensitive personal data can only be collected for the purpose for the purpose or the service that you are going to be offering the data subject. So when I see these things like mental health or physical or condition, it helps me because some of these things actually tie in with other legislation that we have coming on stream, like disabilities legislation and how we treat with persons with HIV and so on and so forth. So basically, in a sense, it kind of levels the playing field in some respect because it is restricting the questions that you can ask a subject depending on what they have come to you for. Here's this one. The commission, this one is sensitive personal data. The commission or alleged commission by him of any offense or any proceedings in relation to an offense committed or alleged to have been committed by him in the disposal of such proceedings or sentence of any court. I'm not saying that you can't ask the questions, I'm going back to answer Michael's question. Based on the service that you are offering to the data subject, do you need this information for that purpose? Relevance. And then process. I think we have gone through process, where we said that basically anything you do with data is processing data. Because you bring it up on the screen and you read it, it is processing data. If you're storing the data, I remember when we're talking about data, as we're talking about personal data, what is regulated is not data at large. It is personal data, sensitive personal data. Alright? I had mentioned relevance filing system and accessible record in my definition. So, a relevant filing system. So, you recall that when I started out, I indicated that this whole concept of data protection gained traction when computers came about. But prior to computers, and part of the reason for that was because computers were able to structure and organize your filing in a way that was not hitherto possible and in creative ways, and made it easier to identify persons by reference to their personal information. So a relevant filing system is a set of systems which, although not processed automatically, is structured by reference to individuals or criteria relating to individuals such as date of birth or employment start date, so as to make specific information relating to a particular individual readily available. So what this is saying to you is that the Act not only applies to information that is personal information that is automatically processed, but also where it is manual to make it readily accessible and making it easy to identify the individual. And the accessible record I had indicated to you would be a health or personal record. Oh, I hope that's not as hard on your eyes as it is on mine. But I hope you can make it out. So, duty. Remember I spoke about duty, breach, damage? So remember that I had the 8 standards that I referred to related to the obligation of the data controller once they have access to our personal information. And they have a duty to treat with it in a particular way. So what the legislation does now is that it gives the subject certain rights in relation to their personal information, because they are basically making the point, affirming the point that the data or the personal information is private, and the person in control of that is the data subject. And so here I put records management Because in the context of these rights, if there's a breach, the organization can be found liable. And therefore, you have to have a system in place in terms of how you are going to either record or manage the information that you have collected from the individuals. So, especially in government, sometimes you go to them and they have information about you, and some banks, they are reluctant to give it to you. Now, what this is saying is that the rights of the data subject is that they must have access to any personal data that is in the possession of the controller. They have a right to it. They have a right to prevent processing that is likely to cause damage or distress. And they have a right to prevent processing for direct marketing, which is the example that I had referred to earlier in terms of the information that you will get on your cell phone in terms of those texts or WhatsApp messages or over the phone. They have a right to prevent automated decision making. I have an example of how that works, which I will get to further down in the presentation. And they have a right to rectification, that is to correct the information that you have, blocking, erasure, destruction, and they will get compensation if these rights are not honored or breached in any way in relation to how the data controller manages or accesses your data or processes the data. And so they have a right to request an assessment from the commission. If the controller and the data subject can't agree in relation to these rights, then the subject has recourse to the controller, to the commissioner. So here's an example. It says obligations of the data controllers relating to direct marketing. So the data controller is required to respond. So there's a system in place to activate for the data subject to enforce the right. So they're not only saying that you have a right to prevent this direct marketing or whatever. They are also putting this in the act, how it is that you are going to manage your right. So in the act, it will have a provision that says that the data controller is required to respond to a notice to cease and desist from the data, from marketing, sending marketing information to the data subject by taking preventative measures such as flagging information, IT again. Flagging information or on your manual filing system, a red post-it that was processed for direct marketing. And in this respect, it is recommended that the data controller use information technology systems and software such as customer relationship management products to incorporate an easy method to suppress customer details from future marketing initiatives. So if you had set up a system that, like Constant Contact, that every Wednesday at 9:30 sends out information to all persons who are affected by the Data Protection Act to hire tTech as an example, and I said, but I do not want to have any of your marketing material. In fact, I don't even know how you got my personal information. I remember your email address would be personal information associated with you. And so once I serve that notice on tTech, then tTech is required to comply. And how do you easily comply? Because some of these organizations that they have hundreds and tons of these emails that they are sending out. So how do you comply? You have technological measures. And you thinking about it now, for example, since I use Constant Contact, there is actually an unsubscribe button. So you click on that unsubscribe button. That in effect is the notice. So so if it weren't Constant Contact, what mechanism were you going to provide to the subject to enable them to notify you that they no longer wish to be contacted? Invariably, once you send out, except where it is a spam or you're spoofed, usually what happens is that you tend not to get any more because apparently there's already something built into the system, and basically that's what they're saying. Here I find that sometimes you put it in and you'll still get the information. You still keep getting the direct marketing material for days before it stops. So here now though, with the data protection legislation, you have to ensure that you put these systems in place. So it says if the direct marketing is the only purpose for which the data are being held by the relevant organization, it is argued that the personal data should be destroyed. So there you have it. I'm so sorry I didn't realize, they told me about the screen, but I realized it has can we get the lights dim up here like a movie kind of thing? You see? Because when I turn it seems like it's a glare, so I'm really sorry about that. Okay. So the obligation of data controllers to inform in relation to automated decision making. So this example, when I was preparing, it came to me in the context of an employment contract. What is amazing, I think, about this, that before I dealt in any depth with the act, I was actually at a seminar on corporate governance, and the presenter was actually talking about the right of someone to whom you basically advertise or offer a job to come and say to you, well, I want you to reconsider your decision not to offer me even an interview. And I found, like, at the time, and this was like the Data Protection Act was being debated, but I had not yet looked at it in any detail. And he wasn't talking about this, he was talking about it in an employment context, and I was like, what? Why is it that I'm offering you a job and there's no this obligation on me just on the basis of the offer to decide to put parameters in place, and that you can question as to whether you appreciate my decision making or not. But the part of the issue here is because this automated decision making is based on the handling and the processing of the person's personal data. So the question is, what information did you put into your system that enabled the system to come to a decision that was not going to make an offer? That's what this is about. And this is how the tables have kind of turned now in terms of those persons who have become high-tech and their offers and so on, or their screening processes are using automated decision making. So what it is saying that, and I've given you the example here, and it says that in these circumstances, if the system and the robots and the AI in the background decide that Rachel is not to be offered a job, then Rachel must be informed as soon as reasonably practicable of the fact that the decision concerning her suitability for the job was taken by automated means. So if that's how you came to the decision that you're not going to hire the person, then they have to know, and then they now have a right to request that the decision be done by manual means. So it says Rachel received the notification, and they must inform her of the steps that they will take to comply with her request and review the decision by using non-automated means. And all this has occurred because you have used her personal information to plug in for the system, for the AI, for the robot to make the decision as to whether you're going to hire her or not. So much for us, well, for the HR people losing their jobs to automation and AI. This is here to tell you another story, so you can spread the word. So, but once you comply with the act and do the reconsideration manually, you do not have to come to an alternative decision. That's not what it is saying. It is just basically saying that because you have put in certain information about me, then I'm entitled to reconsideration using a more, I suppose you're saying, more reliable means. So if Rachel is now not satisfied, see how detailed it is? If Rachel, so this is in relation to automated decision making. If Rachel is not satisfied with the new decision that was taken, and she wants to know how the online decision is taken and what information it was that she submitted about herself led to her being refused, Rachel can make a subject access request that specifies that she needs to know the logic. That's an IT word, not our English reasoning and logic. The logic behind the decision that was taken about her by Jobs, R.Us website. and Jobs R Us must comply with Rachel's rights of subject access within 30 days. So I'm not just telling you this, I'm just saying that now that there's this data protection legislation, when we see the bells and whistles of technology and the efficiency, which we will all agree that they confer on us, then we also have to consider what our responsibilities are when it comes to handling of personal data and just comply with them. It may not be anything. May not be a big deal, but just don't get caught because there are these obligations. Damien first.
I was just
Never. So who is Damien? Oh, Damien. Okay.
I was wondering if that's just in the context of employment, or what about general applications for business?
Processes like credit. Yes. I was just using employment as an example, but I can also see it happening in relation to an application for a credit card. You might have received something that says you are pre-approved for a credit card, your automation, and then they say go online and put in so and so, so and so. That's where the banks are going now. You put in your information and then it might come back and tell you, oh, it's denied. What this is basically saying, to the extent that it was automated decision making, there's a process to be followed for the data subject to find out why they were denied and also the technical, you tell me the word, man. Algorithm behind behind the no. Yes? You were going to ask a question? Yes.
How do you treat the scenario where the repeating of the logic would lead to an exposure to source code or proprietary source code to other persons?
Honestly, I don't think so. No, I don't see how your logic is going to expose or better yet, a good IT person should ensure that the logic does not disclose the source code. Because what you're basically showing is how the ones and zeros connect to equal 0 or 1. That's all that you're doing. It doesn't matter that it's proprietary, it's part of the risk that you take. Is it part of the risk that you take when you deal with personal data? And also, remember as well that this is an introductory presentation. So in terms of that word that you use, a very important word, proprietary, confidential. It will be an important consideration for the commissioner or anybody in terms of either your refusal or the amount of information that you choose to give to the data subject. But I don't think that it is going to be a situation where it allows you to completely say no. So I'm saying, because I appreciate what you're saying, and there could be a lot of argument around it from a legal perspective and from a rights perspective. Michael?
Isn't the implication here that you are entitled to a job or you're entitled to credit? Are these private decisions? These organizations are not supported by taxpayers' dollars. So why, if I apply for a job and I'm rejected by an algorithm, why am I going to take objection to that? I'm not entitled to the job. If I apply to BNS for a credit card and they reject me, I'm not entitled to a credit card for BNS.
No, but that's not what they actually say, because remember that it says that when you ask for reconsideration, they don't have to come to an alternative decision. It's not necessarily about entitlement. Remember that one of the standards of data processing is fairness. So what if there is a glitch, for example, in the algorithm when they ask for the reconsideration? And
this is going to, I want that job, and you must provide me with a reason as to why you have provided me with an interview.
no.
I don't agree with that reason. You must provide me with your logic.
No. It says if on the basis of automated decision making I was rejected, then I am entitled to find out the nature of the information that you had plugged into the system about me that caused you to come to your decision. I am saying to you that in some cases it could very well be fair, because what if, let us say, 6 persons are applying for the job and they mix up the data for Michael versus Neville? That is an example of how it could reap unfairness or against one person as against the other, and I don't see that it is so. It might be cumbersome, but I don't think, and it might only be cumbersome initially because computing and information technology and ICT have always found ways of making things easier. But I don't think it is an entitlement per se, because the act itself makes it clear that it is not saying that you are obliged to make an alternative decision. It's just that the person is entitled to know because you have used their personal information. And so it's really about fairness and lawfulness. What if something, so that is in that context. Now, it is.
This is not going to be burden to this with the obligations on this.
So hold on now. When I'm responding to persons and they get a little bit passionate about some of the views, I like to know, in order to give you an appropriate answer and also to make it benefit other people, what's your industry? When I say what's your industry? No, hear me out. So are you an IT person or do you provide financial services? Right, so your job as an IT person is really to ensure, right, and I'm saying his job is to ensure that you put in the right algorithms to make it not so burdensome. But one has to, if I speak from like just being a lawyer now, if I speak from that perspective, or even as a data subject, there are circumstances in which things could have been done differently in relation to the kind of information that is required and requested of persons.
George, Mike, one of the things that Richard just pointed out, the key thing here with this part of the discussion is around automated decision systems. You know?
Yes.
If anybody uses application like Workday or any of these very advanced HR systems,
yes,
that you people go online and apply or apply for whatever, then the system does some sort of
screening,
spits out to the company out of the 150 that don't apply. Here's the 5 that are shortlisted. That is what this is talking to. It says not just generic.
Yeah, but the other 500 folks who sent in their data could object to that and say, every one of them could say, I want an explanation as to why I am not one of those folks. So the point I'm trying to make is this even enforceable?
It is enforceable because one of the 5 who asked you for the reconsideration and you don't reconsider, they have a right to make representation to the commissioner. So you have to look at the broader context. If the reason you set up, you want to employ, and I'm just speaking broadly, you want, and we're using employment as an example, or maybe even a credit card. Make no mistake, when you offer me a credit card, you're not offering me a credit card because you like me. You're offering me a credit card because you're selling a service from which you can make money. When you decide to offer me that credit card, that money that you want to make gets nowhere unless I give you certain personal information. So it is my personal information together with your desire to make money that causes you to plug it into the system using the most efficient way from an economics perspective to process the information and tell me yay or nay. Why in the circumstances of that partnership shouldn't I have some rights? It can't simply be that you are going to be able to tell me no. That would be my response to you.
But it almost sounds like we're regressing because in many industries there are many automated decision-making tools. So if you are now going to introduce the ability of an individual to question the integrity or the authenticity of the algorithm used to make this decision.
All right, but you see, what you're not realizing generally with some of these things. So I'm going to use the Evidence Act on you. So let us say No, I'm just saying. Let us say. I'm in court now, for example, on a matter that concerns handwriting. And the handwriting expert, the question document examiner, says to me that I have used a computer to assist me in coming to my decision that this is or isn't the handwriting of that particular subject. And I'm not talking about data protection now. When I get into court as a lawyer, the Evidence Act says that I am entitled to query whether on the day that the data was produced from the computer, whether on the day that the data was produced from the computer was in working or functioning condition. In my mind, that simply goes back again to the working of the system, ensuring that the system is working, the logic of the system, and so all of these things are already there. Sometimes when we regulate and we make laws, we just keep some of the things out of the court because it's either you're going to answer the employee or you go down to court and prove that your computer working. So it is there. That's all I'm trying to say. It's just that because you have no reason to be in court on a regular basis, you may not recognize that some of these things are already there. And if we go back again to the lawfulness and fairness of processing, we may use the machine, and we are saying that the machine is fairer than the human resource manager who may sit and decide that you're black, you're white, you're Jew, you're gay, you're Christian, you're Muslim. And so you're saying that the system is fairer. But what if algorithms are built into the system to just exclude you in a similar way? So those are the things that you have to look at broadly when you're thinking about that the system can be configured in pretty much the same way to operate like the human mind. So that's why they're saying that if it is that we are now going to move to use computers to automate data, then persons shouldn't be able to hide, for example, racism behind the automation. That's it. And remember, I'm just answering you generally, yes.
Is it so much so the algorithm itself or the actual information, the personal information that was taken into consideration and the person is entitled to?
No, the right that
in terms of saying, okay, for instance, I applied for a job that requires me to walk, but I'm in a wheelchair, so I can't get that job. For instance, right? And that's a part of my personal data. If I say, why wasn't I considered for the job, and then the person comes back and says, well, really and truly because of the duties that this particular job requires, rather, you need to be of a particular have certain physical capabilities, and based on information that was provided to us, you don't have those physical capabilities, so as such you are not you can't be shortlisted for this job. And is it that?
no, what you're trying to do, here's what we're all trying to do here. Hold on. What we're all trying to do here is to fit ourselves within what the prohibition is. That's going to be impossible.
I was trying to understand if it is really the algorithm itself, because I think that's what the IT professionals here are struggling with.
No.
They have to divulge what the algorithm
No, what I said is that, no, hold on. What I'm saying is that the reason that you are required to disclose the information is because it's one of the rights, my rights as a data subject, that once you use my personal information, I am entitled to know how it is that you used it to make a decision in relation to me. In relation to automated decision making, we have seen that there is provision for, even when you respond, if I am not satisfied, I am able to ask you, well, what is the logic of the automation? So it gets there. But the right on the fact, my right rides on the fact that you use my personal information.
But I understand what triggers my right. So I was just trying to assist to say maybe it's because they're thinking algorithm technically and IP in relation to algorithm, and I was just trying to say maybe it's not that you would be required to divulge your algorithm, it's just to divulge the actual information that informed decision and why it was that information informed decision.
Logic sounds like system to me, though. Yeah, logic sounds like system. Yes. Well, I'm going to leave the question because some of the questions that you're asking, for example, it's a spirited debate, and I like it. But the point is, at this, if we get our knickers in knots at this point, there are some of the things that will get you out of doing or complying. Or for example, if you notice I jumped straight to, it could very well be a matter of contract in relation to this automated decision making. So I said a data controller may insert a clear statement in its documentation to the effect that the automated processing system to help it consider whether or not to enter into a contract with the data subject. So it depends on what you put in your contract when you are saying to the person, here it is that what is going to help me to do to offer you or to make the decision in relation to this contract or application for a loan, and you kind of put some exclusions or limitations on it. So it could also be that. So it says, then provided the data subject has asked for such a decision to be taken and either decision is favorable, or there's a right of appeal against an unfavorable decision, the processing will be exempt from the above provisions. So what it is that you really need to have someone in place in your organization who understands how to treat the act and what you're going to plug into your system in terms of going out to the data subject in order to comply. Alright? We're not taking any more questions until the end of the presentation. No, I had just said that we are going to wait until the end to take the questions. So please write them down, we'll go faster. So here's an example of exempt decisions. So a bank is considering an application by Michael for a loan. Michael, I foreshadowed that I was going to see you. It has forwarded standard documents to Michael, which informs him that the decision whether to make the loan will be taken automatically by the computer. Michael reads the documentation and applies for the loan. The loan is then extended by the bank. The question of Michael's data is exempt from the right to prevent such processing. Because you agreed. You read the documentation, you applied for the loan on the basis that you're agreeing that you want the process to be done automatically. So that's why I said it could also be a matter of contract. Right. So that's why I said hold the questions, because I'm going to try my best to touch on various areas. And this, as I say, is a teaser, is a very tedious stack bill of 114 pages with whereas and wherefores. So you're not going to be required to do it on your own. I think in part that's why tTech is also here, that's why tTech asked me to come, and I'm sure you have your persons in-house or wherever that you can reach out to, alright? Now, remember that I had made reference as well to the obligation to appoint a data control officer. This you can't get past this. You have to do this. It's a requirement in the Act, and if you don't do it, there will be sanctions. And so the purpose of the data protection officer is to ensure compliance with the processing standards. Remember those 8 processing standards? So it's a data police basically in-house. The person is required to consult with the commissioner in the event of doubt. So all those doubts that you have now, or whether you can or cannot do, or how you configure your system, the role of your data protection officer is to ensure that you are in compliance, and they do this by acting basically as a bridge between you and the data commissioner, who is the ultimate enforcer. However, if the data control protection officer advises you that there is a breach and gives you time to remedy that breach, you should take it. Because if you don't remedy that breach, then they have a duty, not just right, a duty to report you to the commissioner. So this officer is almost like they're there, but they're like a watchdog for the commissioner, which you actually pay. So in this, another right, we spoke about this in passing, that another right that the data subject has is to ask the data controller to correct their information in terms of any inaccuracy, to rectify, which means to amend or block, erase, destroy as may be required any inaccuracy. So now I get to the point where I spoke about driving compliance and the sanctions. And I've touched broadly, I don't know if Chris is going to do this in another presentation, but I've touched broadly on your management structure. I've done this because within the Act, what you are finding out is that boards can no longer sit back and think that they will not be liable or responsible for data loss. They will be responsible in terms of criminal sanctions in relation to data loss, so that a more strategic and deliberate approach will have to be taken in relation to managing data and your IT systems, also in relation to security. The officers of the company and you have the director, manager, and secretary who are specifically named in the Data Protection Act. And just possibly as an aside, the same thing is in the Cybercrimes Act. The same kind of obligation on management structure. And notice I talk about officer. So I talk about our manager, talking about some IT committee and some managers and who will be responsible. So whichever officer they are going to choose to take before the court in addition to the company. The court can't go to prison, people remember. The company can't go to prison. So make sure you document. And apart from documenting, hire people like tTech and whoever else is out there to assist you in setting up your IT systems. IT is now a priority. I've often heard IT people complain that they are the prodigals and the black sheep. Is that it? The black sheep in the organization. No more. No more. So you make sure you document, because that is how you are going to avoid liability. In terms of the Data Protection Act, so it talks about the corporate liability, and it tells you what the compensation is going to be in relation to the corporate liability. In relation to personal liability, they're saying that where the organization commits an offense, and look at this now, and the court is satisfied that director, manager, secretary, or similar officer of that body corporate connived, conspiracy, in or consented to the commission of the offense, that person shall also be proceeded against or punished. And if the corporation is run by its members, they shall be liable accordingly. So I think of like industrial and provident societies or companies limited by guarantee on that side when it talks about members. So you have the committee of management. But I'm just saying that the liability is similar to the liability that is under the Cybercrimes Act, and both of them scream for attention in terms of your IT infrastructure and the priority that you give to your IT infrastructure and systems in terms of particularly like the security of your IT system. That is what is going to be required to come up to par. That is what's going to be required to be robust in order to be able to avoid liability, quite apart from the systems and policies that you put in place to ensure compliance, which I'll get to briefly. So I did, this is the Cybercrimes Act, as I was explaining, so it's there for good measure. Under the Data Protection Act, the prosecutions, there can be no private prosecutions by the data subject. And so the prosecutions will be with the consent of the Director of Public Prosecutions or by the Commissioner with the consent of the DPP. You don't have a problem like with Indicom now where there's this issue. It is very clear that it is with the, it is by the Commissioner with the consent of the DPP. And the penalties for breach, they're stiff, like $5 million and so on. But I thought that instead of, I put here where the sections are, where you will find the penalties, but I'll put what the breaches can be. So the breaches can be processing without registration, carrying on specified processing other than by assessment, unlawfully obtaining personal data, prohibition on requiring certain records, and the failure to comply with a notice as concerns an enforcement notice. Because a whole enforcement mechanism inside the act to ensure compliance with it. And so that's why your data protection officer is also important. On the civil side, so it says that the data subject or an individual, it never said the data subject, an individual who suffers damage by reason of any contravention of a data controller of any of the requirements of this act is entitled to compensation for damages. An individual who suffers distress by reason of any contravention by a data controller of any of the requirements of this act is entitled to compensation from the data controller for distress if the individual suffers damage by reason of contravention or the contravention relates to the processing of data for special purposes. So it's again this background of rights, duties, and sanctions and prosecutions that I have suggested that, as I said before, you need to have measures, and I use the Cybercrimes Act as my backdrop, measures to prevent unauthorized access to personal data. You have to have that, and in the Data Protection Act it is stated in a different way, so that the accidental data loss and so on that you are seeing, thank you, with Target and Saks Fifth Avenue and Walmart and so on. Right, even with Facebook. I'm trying to figure out why they're treating them with kid gloves at the moment as Facebook. But the data losses that you have seen, all of those are now basically here. Once this act is passed, these are the risks that you have. And the system that you build, therefore, will have to have, I will call them access control systems. You have to put in place access control systems to ensure that personal data is not lost or stolen. Access data control, the personal data, as you will appreciate, is a hot commodity these days because it can be used to completely steal somebody's identity and do a lot of damage. So if in doubt in terms of how you navigate the system, one of the ways to look at it as well is also in the context of what is required of you under the Cybercrimes Act. The Cybercrimes Act is not saying prevent access completely. It is saying you are to prevent unauthorized access. And when we started out, we were saying you need to devise systems to ensure that the only people who have access to personal data are the persons who need to have access to personal data, which comes down again to unauthorized access or unauthorized modification of access. I thought that this is from the management and legal and regulatory responsibilities. You're going to have a governance framework in place. Especially when you're going to be try to seek to avoid liability, you have to have a governance framework in place, which is why Michael was asking me about what is adequate and so on. And when these are the things that a court or a commissioner, which will act like a court if it has to assess you, will be looking for in terms of what systems did you have in place in order to protect the personal data or the personal sensitive data against technical loss. So, as I said, a more structured and more deliberate approach will have to be taken and to understand in terms of understanding what the requirements are, what regulations are to be complied with, and set the tone or the mandate as to how it is going to be done. Because in a sense, there's no point in complaining about it. You have to, it's here, so you have to do it, you have to comply. And so when I speak of management, one of the things that, for those in here in management as well, I'm suggesting that you have to assess the impact of non-compliance or compliance on your business and provide the resource and funding to ensure that the issues are addressed. That is one of the factors that will be taken into account in determining adequacy. You can't shrug your shoulder at compliance because the consequences are too great. What is adequate? What do you have documented to show that you address your mental system and that you put things in place in relation to comply with the system? It says, obtain external or internal assurance as required that the systems have been addressed and the controls have been established.
Yes.
I'm getting old. Well, remember, you can't ask about the age. Yes, so we're now going to have a wonderful. I'm getting reinforcement, so hold your hand a little bit.
Ladies and gentlemen, please join me in thanking Georgia Henry. Grab a seat, folks. Ooh, corner. Right, yes, grab a seat. Yes, please. Okay, so ladies and gentlemen, we are asking our Director of Operations, Mr. Norman Chen, and also our IT Officer, John Gibson, IT Security Officer. John is the man who usually answers all the questions about IT security. We know that there are a few questions, so first and foremost, before let's ask Julian are you ready to give her her little gift yet, or when she's ready to leave, or when she's ready to leave. So, ladies and gentlemen, thanks for coming. The topic, when we started looking at things that folks been asking us about, IT security is something that's been on the agenda for several years now. But then, more importantly, we saw this act coming into place, and there have been some debates about it, and there's been lots of commentary in the media. And so we decided to reach out to one of the persons who have been talking about it and has been making a number of presentations around town, and invited her here. So, question time. I've also asked between John and Norman to kind of give us a quick overview as to some of the solutions that we offer that would be able to assist in helping and protecting your data. The data once you're collecting this data in-house, how you protect it. So I don't know, John, if there are one or two things you wanted to mention, or Norman, who's going to go first? Okay.
Thanks, guys. It's an interesting presentation. It touched on several very, very important areas as it surrounds the Data Protection Act. A big part of ensuring that you're compliant with the Data Protection Act is starting at the governance level, which Georgia mentioned quite a bit. You have to have a strong and robust policy infrastructure in place in terms of how you classify data, how you identify what's personal data, what's not. You have to have very well-defined procedures in place in terms of how you handle that data. And once you have those two things in place, then you can now choose the appropriate technology that you will apply to processing the data, securing the data. So you may want to look at things like, on the technology side, you may want to look at things like data loss prevention. Those systems will help you manage the flow of data within your organization, help you define who has access to it and what kinds of access those people have. I think that's important as well is you need a good security incident response process and a security incident response plan. Things will happen. You may have the best of policies, the best of procedures, and the best of breed technology in your organizations, but they may become outdated, and a security incident may happen. You have to be able to demonstrate through an incident response plan that you have clearly defined steps in terms of how you rectify any incidents that may occur. A very important third area that is necessary is more technical than anything else is vulnerability assessments and penetration testing. That will give you an idea of the weaknesses that exist in your system and surrounding the systems that's holding this data that should be protected, and will give you some ideas in terms of what you can do to protect it and to improve the security of the systems that you have in place.
Thank you very much. Nominate please.
Yeah, sure. So, I'm glad with the corporate governance that it will become more, IT will now become an agenda on boards. Because one of the things that we've realized in meeting with a lot of our customers is that IT actually doesn't even have a representation, a direct representation on the board. Quite a few customers. So this is actually very important, and it actually will enable us to get things done a lot more, having IT on the agenda. Another thing is compliance, definitely. And there's a launch later at 5 with Sal. We go into enterprise content management, which I think is also a very important part because that will help a lot with the compliance and showing, and putting in the securities. Because when you think of the amount of data you collect, and then every time you print it on a piece of paper to look at it, what do you do with that piece of paper at the end of the day? It's still on somebody's desk, somebody crumples it up, throws it in a waste paper basket. What does that mean for your organization? So, there's so much data that we're collecting, whether knowingly or unknowingly. And processing it. You're collecting it and processing it, you don't even realize that you're processing it. That IT is now going to become very, very important in your day-to-day operations.
Thank you.
I think it's also interesting that Norman mentioned the printing aspect. I was reading an article a few weeks ago, and there's a I don't know why it was a staggering statistic for me. About 60% of print jobs are not collected by the original person that sent it to the printer. So it's just left there. Seemed kind of high to me, but then I kind of took a look at it and I said, you know, how many times have I gone to a printer and picked up a sheet of paper that has been there for 2 or 3 days that, you know, so things like that becomes very important. And the implementation or the institution of a technological solution to guard against that. I mentioned DLP earlier. DLP is something that would help you with a situation like that, where, you know, if you're processing data, you can only have a certain amount of access to it. For argument's sake, you can't print it. You can only read it.
So I know there are, first and foremost, let me just say, George, that I'm very, very, very happy that you came and spoke to us about this thing, because 80% of this thing I didn't know. I know the app was there. I have read articles and short summaries, but the detail that you went into, without getting into 114 pages, because we at the office were in fact going through the act ourselves. Each of us on the management team, we were given sections to read, and we came into a meeting, and everyone was to explain their understanding of their section, and then we were to kind of sum it up. So we even doing that and going through that, yeah, we kind of had an idea, but you have come to lighten my darkness, right? Ladies and gentlemen, questions. I know there are a few hands up. Yes, okay, so the first hand is up around there. Are we to carry these mics around there, or are they going to shout, or how is it going to work? No? Okay. So good question.
Yes, remember that that's the data processor. That's the data processor role. So I give you the examples of like debt collection, payroll administration, and I don't know what every business does, but there are things that you would end up having to outsource. The reason people outsource things mainly is because of cost within. So it's more cost effective to outsource.
No, I was just wondering if the app specified that the people should be employees.
No, they are not. That's what I'm saying. The data processor is not an employee.
It's only like an auditor to me. It's only like an auditor.
The data controller would have to be though.
Yes, the data controller is subject to the act, the data processor is not. And therefore, that is why I had indicated that detailed arrangements will have to be made between the data controller and the data processor to ensure the data processor's compliance when there's outsourcing.
Alright, second question. The consular offices of various embassies, are they exempt?
It's something that I have to check. The bottom line is that first of, because you have asked a question that touches on cross-border transfer of information. I don't know where, for example, the US embassies store their information, all of that information that they collect. But then it touches also on the whole question of the fact that surrounding the embassy itself, remember that within there is America. So that's a data transfer issue. So it's difficult to answer your question in the way that you have asked, but it is something that I will definitely have to consider because it will come up.
Another hand over there.
All embassies are in wherever, all of them. No, there is wherever the embassy is, my understanding is that within is where you'll find Julian Assange. I'm sure you appreciate what I'm saying.
You're saying that the consular, the embassy and the consular office is 2 different locations. So I think we're getting into some semantics. It's foreign side, both of them. Okay, another hand over there.
First of all, let me congratulate you on a very informative session. My duty is to handle data where I work, so I really appreciate the information. But there is a matter of concern to me, and will eventually be a matter of concern to my organization. In my industry, we are governed by POCA, AML, etc. We have to integrate that into our data collection procedures. However, we have been finding that it is very difficult to enforce some of the what you would call it, obligations. I'm not sure I'm using the term right from your legal standpoint. But
standards?
the standards or whatever the case may be. They are very difficult to enforce primarily because they tend to be so ambiguous. However, based on this Data Protection Act.
Hold on, just a second, just for clarification. What's ambiguous? The one on the requirement on the Proceeds of Crime Act or the data? Oh, I see. Okay.
Yes. So because we're now looking at this Data Protection Act, based on what I'm seeing, there will be quite a lot of overlap because the Data Protection Act seems to go to a finer level of detail in terms of what is to be protected. Do you know of, or are you aware of any discussions to clarify this POCA AML Act based on what we're going to be required to enforce from this Data Protection Act?
I'm not aware of any discussions. I've had some association, as it were, with Proceeds of Crime and AML, but let us not, you are collecting data, fine, for the Proceeds of Crime AML requirements. However, where the data subject will be protected is how much information that you will need for a particular purpose. And remember that it spoke about in accordance with an enactment. So, for example, it's hard for me to answer you specifically because I have some views about some of the requests might well be overbroad. So you have due diligence, enhanced due diligence, and so those are the parameters in my mind within which you have to look at your email and see what you are collecting from persons, and once you collect it, if it is personal information, what the Data Protection Act is saying is that it must be treated in a particular way. So it's not necessarily about the terms, it's not everything that you collect that will cause you to be subject to the Data Protection Act. It's to the extent that you collect personal information that is capable of identifying a person or the sensitive personal data, biometric information, and so on. So biometric information, for example, doesn't fall within AML. Name, address, and so on. So I'm just saying that it gives you some cause for further thinking, as I said, deliberate thinking in terms of how you now collect data in relation to whatever enactment or contract or relationship causes you to collect personal data. And each case will have to be considered on its facts. So if I find that you're going to need data protection or privacy, either lawyers or practitioners more, because in the EU, I was speaking to Sal earlier, and my experience has been that you have lawyers who are just privacy specialists. That's all that they do. So that is where we are going. You are going to have to find someone who specializes in that area and who knows it very well. And some of it, we are still going to bump into problems anyway because it's subject to interpretation, as you say.
Another question? Any other questions? Yes, Karen.
Well, what is, you said that the regulations are not yet defined. Sorry. You said the regulations are not yet defined. What is the timeline?
No. The act is not yet defined, so if the act is not defined, there's no obligation to do regulations.
Okay,
so let's start with that. Also, when the act comes into effect, one of the provisions that I have not mentioned, and I don't know if it will change, is that it gives the data controllers a year, so it's called a transitional period, to become compliant with the act.
Okay.
So there's a transitional period. It's not like it's passed tomorrow, it was April 20, and then you are immediately subject to its terms. They're giving you a year to get yourself in order. I can't recall what the submissions were at the Joint Select Committee in relation to that timeline. If people were saying it's too short, I think maybe the banks were saying it's too short, so I don't know what they're going to do in relation to that transitional period. But
the year is too short?
Yes.
Okay, but in terms of finalizing on the act, what's the timeline for that?
I can't know that. They will never tell you. They don't even tell themselves.
Yes, Richard. And then.
In terms of some of the definitions, you spoke about data subjects. Are data subjects citizens of Jamaica from this jurisdiction standpoint? Is it Jamaicans, or if it's a foreigner,
Anybody who is in Jamaica.
Anybody who's in Jamaica. So for foreign firms who, for instance, have a website which Jamaicans access, would the act apply to those?
Remember when I start, one of the things I never did in the presentation is that section of the act that spoke about cross-border transfer of data. But remember that when I started out, as I was explaining to you that I think we are a bit behind the 8 ball, because in the EU again, but that's where I've had most of my contacts, and in North America, that's where the debate is in terms of cross-border data transfer. But I did not look at it for the purposes of this presentation as I could have. But questions have arisen in relation to that, in relation to who is really the data controller, where the data controller is located, and all of those things. But I'm sure Chris will do another forum like this where we can come and we can just do data in the cloud. Because in effect, that's kind of that. I can do that, but I did not. It's a whole area by itself, so it's not something that we can fully address today.
Okay. You also mentioned a data commissioner who will adjudicate on some of these matters. Who is that person going to be? And in other words, which office?
It's going to be the office of the privacy commissioner. Well, that's what it's called in other regions, the office of the privacy commissioner, or office of the data commissioner. And it's almost like, because it's notice we have a commission of Indicom now, so it's going to the integrity commission. So it's going to also be a commission of parliament that is set up and structured in that way to ensure compliance with the Data Protection Act.
Okay, thanks.
Julian, behind you.
So to be clear, it's the Office of Information Commissioner, similar to the Integrity Commissioner.
Very good presentation. You spoke about maybe another session on cloud storage. I'd be interested in something like that because most of the systems we work today are moving data out of people's server rooms into cloud.
Yeah, that's true.
And that's really a big thing coming. So that would be really useful.
Thanks for the feedback. Yes, so ladies and gentlemen, we would like to get feedback on other topics that you'd like to hear from us. We want to do more of these lunch and learn sessions. And so we hear loud and clear now that there is some information required on cloud storage and legalities and cross-border transfer of data. So, George, just start studying that one, please. I know you know it already, based upon what presentations I've seen you do already. There was another hand on the back. Yes, go ahead.
Yes, thank you very much for the information.
I should be asking people to identify themselves, you know. Nick, sorry to start with you.
All of a sudden.
All of a sudden.
Nicole Case from First Global Bank.
Yes.
So my question relates to the Rachel example that was given, related to the automated response systems and so forth. And you mentioned that the subject, Rachel, has certain rights and so forth. I wanted to understand if the Act would allow the data controller to put in place terms and conditions that can allow you to waive some of the rights of the subject, Rachel, so that you don't go too far and wide and create a problem.
I don't think the Act allows it, like just says it. But what I put there when I said that it could be a matter of contract, I was just being a lawyer. Because I don't see any provision yet, and we don't know what the final thing is going to be. I don't see any provision yet which says you can't contract out of the Act. Because remember that one of the first conditions of processing data is consent. So the question could very well be, well, what can you get them to consent to? When I have an office down the road, it's not just Christian can go and look for it.
So I have a question. Some of you are our customers, some of you are not our customers. And how did we get the contact information for the folks that are not our customers? A, we call your office and ask for who's in charge of this, and they just told us, right? Or we knew somebody that knew you, and then we got your name and email address, and we sent information to you. So, am I in breach of any sort of
Well, it's marketing, isn't it? But you see, what you have done, you have asked a third party for the information of the person you have sent material to them. So you have already processed the data.
Yes.
As to it, you are not yet in breach. You will be in breach now if you said Nicole case.
Yes, yes.
Yes, so when Nicole says to you, well, I don't want you to call me anymore, and do not send me any more information.
Nicole,
that is when that is when the breach.
Okay.
It's triggered. It's triggered. Because there are things that you can do and the matter ends there. So the act is not just about punishing you, it's also about compliance.
Compliance,
so
okay.
if you comply.
Yeah, I have a question on that first. So, your work email and your work phone number is considered personal information, right? But if the company says it's okay to use the information,
you gotta talk
to the mic. No, I'm saying is that your work email and your work phone number is considered personal information. But if your company says it's okay to use the data, but you personally say no, what happens in the law?
Well, I'm here thinking, and again, I haven't checked it as yet, but I'm just here thinking to myself, there's no way that your work email or anything work can be considered as your personal information. And employers too had better be aware of what, just similar to how now you might have to be putting in place like social media policy, which is a big part as well of your data protection compliance. But just in the same way that you're going to be putting in social media policies, your employment contracts might very have to be different in terms of to whom does this information belong, like the handling.pro domain on your email or the phone number for my work. And I don't know that I would treat with it if I were to argue, depending on which side I'm on. That is personal information.
So Georgia, so 1 second, Mike. Georgia, one of the things that we have been telling customers for the last few years, since we've been implementing Office 365 and a number of software applications for customers' email, is that very thing to say that you have a bunch of folks that are using a Gmail account, or Outlook account, these things for their offices, for their, they have their name dot, the company's initials dot cwjamaica.com as an email address. And one thing that we have suggested is that you, Mr. Company owner or Mr. Person responsible for legal activities in an organization, have no jurisdiction over something that it's not really your own. So we are saying you have your own handling.pro. Through Office 365, it is yours. The company has now issued an email address to you under the company's name, so they now can have legal access. It is now something that they can use as evidence in court and things like that, versus somebody using their name something at cwjamaica.com. Any commentary on something like that?
The danger I find with the say they use handling at cwjamaica.com, right, or their name and HGH at cwjamaica.com, is that the person who received the information is going to perceive that it comes from the organization. So truth be told, maybe you have little policies inside, but what you guard against sometimes with these compliance issues is the time and effort that you're going to spend to say it wasn't me and I didn't know anything about it and I had asked for them to do X or Y. So again, when I spoke about having these policies in place, monitoring compliance and so on, and that one is just a no, don't do it, because remember, there is one of the standards or rights of the data subject, which is to prevent communication to them which causes them distress. So what if these people who like to send these jokes and good morning emails or WhatsApp that people like, it may very well cause some people distress. Like you appreciate what I'm saying. So what happens in relation to that? And those are the things that you need to guard against when we speak about a governance framework in relation to your employment.
Right.
Employment environment. Michael has been chomping at the bit.
No. Back to the racial question. What about the manual world? What if your processing is manual? Does Rachel have the same rights because you're using her data to determine whether she gets a loan or whether she gets a job with you? Does that apply in the manual world?
Well, your question is ambiguous, so I'm going to answer first. I know I'm going to address both ambiguities. But I'm saying it's ambiguous. It has two meanings, because remember that the reason for the issue with Rachel is because of the automated decision-making process. However,
no, you said that Rachel could question the logic of the automated
correct,
process.
yes.
Can she question the logic of the manual process that comes to the same decision, basically?
Not that I'm aware of.
Not on this act.
Not that I'm aware of.
So
So remember that I'm relevant. No, but hold on. You are asking a question that relates to a specific standard. And the specific standard is automated decision making. It's not talking about decision making. It says automated decision making. So my reference to Rachel was only in relation to the standard that says if you use an automated decision-making process, then Rachel has certain rights. If you did not use that process, then the standard does not apply. Because we are talking about, that is why when I started out, I said, even before I gave you the definitions, I said, these are your standards. Why you don't use like the standard like a flag with flag? You know that they call the flag standard sometimes. So just put up the 8 things as your flags. Remember I said it? So if you have the 8 things as your flag, that's going to be your guideline as a start. That when somebody says you have done something wrong, you just look up and say, which of these 8 does it fall into? So you could start there.
So, I mean, I know I can answer this, what I'm going to answer, and you probably can't either, but what is the difference between automating the logic and a person who gets 1,000 resumes and discards 500 and then by the second in a day? Because that happens in America. I mean, that is discriminatory.
No, but
I think we're straying a little bit from our topic of what we're talking about. But then you know what I'm here. It's an issue and it's a topic. All right, we're taking one more question. One more from somebody who don't ask it. All right, okay, doesn't matter. One more or 2 more. Yeah? I see 2 of the hands that went up before. You guys are trumping a bit with questions. That's good.
My follow-up question, and you touched on it, related to the concept of the impact of social media and your image. Basically, let's say a photograph. So does the Data Protection and Privacy Act create more restrictions on your freedom of just taking photos and using it without permission?
Right. Well, if we look at what is personal data, it talks about any information, whether physical or social, that can be used to identify a person. So that's going to be personal data. So it could. Because in a photograph, I can see that it's your nose, your hair, and so on. So I don't have to put your name. I don't have to say it's Rachel, whoever we don't have to say it's Rachel case. You look at the photograph, and because you know Rachel or somebody who looks like Rachel, you're going to be able to identify Rachel from that.
Since you mentioned photo.
Since you mentioned photo, why not?
Because it says here, I'm just refreshing your memory, it says personal data means data relating to a living individual who can be identified from the data or from the data and other information in the possession of or likely to come into the possession of the data controller. But so remember that this act is not talking about what individuals just do on social media. It is talking about what happens in relation to a data controller on social media. So that's where we came into the employment context.
Fantastic. Ladies and gentlemen, thank you very, very much. Everybody clap yourself. Right, for coming. Thank you. Georgia, you have been a beacon of knowledge for us. John Norman, thank you very much for coming and giving us an overview of what the IT component is. So, a little token of appreciation. Thank you very, very much.
Data privacy.
Thank you very much. As I said, ladies and gentlemen, this evening we're going to be having a session on document management, enterprise document management, records management, and we have partnered with an organization called Large Technologies out of Canada. Sal gave his introduction earlier for those who were here and heard it. So that starts at 5 o'clock. We did have a whole afternoon of activity started, but due to some feedback, we made some changes and split the lunch event with the evening launch event. So please come back if you can, and we'll be talking about File Nexus, which is a piece of technology that helps us to reduce tremendously the amount of paper shuffling in your office. We have visited a few customers already and spoke to them about it. And we're looking for a few reference customers in Jamaica. So those reference customers will get the very special upfront reference customer pricing. The technology is a cloud-based technology. It allows you to get a document management solution up and running within 2 weeks. Now, usually when we tell folks that, they roll their eyes over because they're like, lie, impossible, can never happen, until we actually do it, until we actually do the quick demo and show them. But the technology is amazing, and the organization, they've been touching hundreds of thousands of people worldwide. So at 5 o'clock we'll start that. So hope to see you back here. Thank you very, very much.